As I indicated before, I will follow the sentencing agreement between the parties. I do think it's an appropriate resolution. Mr. Walter's correct. There are a number of cases that perhaps some would consider to be more serious than this one. I don't know that I consider them to be more serious than this one, and I'll explain what I mean by that in a moment. That have sentences that are close to this one, or maybe even slightly less. But I do think a sentence of this length is absolutely appropriate. I have rarely seen, if ever, a case that has affected so many people so deeply. I think that the human loss from this case and Mr. Walter's behavior is impossible to measure and calculate. It extends beyond the victims of the counts for which the jury found Mr. Walter guilty. As one of the other victims mentioned, these are only the victims we know about. And as some of the statements that we heard this afternoon demonstrate so well, that human loss and the damage goes beyond even just the direct victims. It affects all of the people who are close to those victims, their mothers, their fathers, their siblings, their partners, their children. And it just has sent a devastating and horrible ripple effect through our community. And I don't know that I've ever seen a case like this one that's had that widespread of an effect on people on such a deep and personal level. This case is truly unique in that way, and that is why it absolutely justifies a sentence of the length as the one that I will impose. I'm not going to reiterate what the victims already said so well, and that I could never say as well, about the terror and sense of violation that Mr. Walter's behavior caused. And I will just say that I think that I will always wonder how their descriptions of that terror and sense of violation register for Mr. Walter, if they do at all. And unfortunately, I fear that perhaps that terror and sense of violation was the point for Mr. Walter. And that is a chilling thought. And it is another reason that this sentence is appropriate. It is also appropriate because it is my hope that the waiver of the right to appeal and collateral remedies will also serve to give the victims a sense of closure that our system can often not provide. And at least perhaps we can provide it in this case. With that said, I will follow the agreement of the parties, and I'll do that now. Beginning on the case for which we received the jury trial findings last year, it's 23 CR 38838, count 1. The grid block is 6A, and I will impose the presumptive sentence of 30 months of prison. That will include eligibility for all credits. All of these sentences that I'm about to impose will. They will include eligibility for all credits, including credit for time served and good time and work time credits. They will not include eligibility for programs such as alternative incarceration programs. I will order that the sentences also be served nunc pro tunc, relating back to the date of Mr. Walter's original arrest on his probation violation matter that is pursuant to the agreement of the parties. And I will also impose on all of these sentences the required 24 months of post-prison supervision. And I will also include the recognition that each offense is a sex offense under Oregon law, specifically ORS 163A.005 sub 5 sub small w. And I will waive the financial obligations associated with each conviction because of the length of the aggregate sentence that will be imposed. So those are conditions that will apply to each of the prison sentences that I'm about to impose. And as I indicated before, the first is on count 1, 30 months of prison pursuant to 6A.
And excuse me, Your Honor, is the court going to allow the credit for time served pursuant to 137370 subsection 4?
I am, and that's what I meant by the phrase that
non-pro-tunc.
Back to the date of the arrest of the original probation violation matter, and that is the intent of the parties, right?
Yes, Judge.
Correct, Your Honor.
And as counsel have indicated, that is pursuant to ORS 137.106 sub 4 sub 8, and that'll be included on the judgments. On count 2, the grid block is 6A, and I will impose 30 months of prison. That amount of prison will be consecutive to the prison imposed on count 1, as well as all other counts. I will impose on count 3 30 months of prison pursuant to a grid block of 6A. That prison will also be served consecutively to the prison imposed on counts 1 and 2 and to all other counts. On count 4, I will impose 30 months of prison pursuant to a grid block of 6A. That prison is to be served concurrently to all other counts. On count 5, the grid block is also 6A, and I will impose the presumptive sentence of 30 months of prison. That prison is also to be served concurrently to all other counts. On count 6, the grid block is 6A. I will impose 30 months of prison. That prison is to be served concurrently to all other counts. Count 7, the prison sentence is 30 months pursuant to grid block 6A. I will order that it be served concurrently to all other counts. On count 8, the grid block is 6A. The prison sentence is 30 months to be served concurrently to all other counts. On count 9, the grid block is 6A with a sentence of 30 months of prison to be served concurrently to all other counts. On count 10, the sentence is 364 days of jail. That will be served concurrently to all other counts. On count 11, the grid block is 6A. I will impose 30 months of prison to be served concurrently to all other counts. On count 12, the grid block is 6A, and I will impose 30 months of prison. This amount of prison will be served consecutively to all other counts. On count 13, the grid block is 6A. I will impose 30 months of prison to be served concurrently to all other counts. On count 14, the grid block is 6A. I will impose 30 months of prison to be served concurrently to all other counts. On count 15, the grid block is 6A, and I will impose 30 months of prison to be served consecutive to all other counts. On count 16, the grid block is 6A, and I will impose a prison sentence of 30 months to be served concurrently to all other counts. On count 17, the grid block is 6A. I will impose 30 months of prison, and this amount of prison will be served consecutively to all other counts. On count 18, the grid block is 6A, and the prison sentence is 30 months to be served concurrently to all other counts. On count 19, the grid block is 6A. The prison sentence is 30 months to be served concurrently to all other counts. On count 20, the grid block is 6A. The 30 months of prison will be served concurrently to all other counts. On count 21, the grid block is 6A. The 30-month prison sentence will be served concurrently to all other counts. On count 22, the grid block is 6A. The 30-month prison sentence will be served concurrently to all other counts. On count 23, the grid block is 6A. That prison sentence of 30 months will be served concurrently to all other counts. On count 24, the grid block is 6A. That prison sentence of 30 months will be served concurrently to all other counts. On count 25, the grid block is 6A, and the 30-month prison sentence will be served concurrently to all other counts. On count 26, the grid block is 6A. The 30-month prison sentence will be served concurrently to all other counts. On count 27, the grid block is 6A. The 30-month prison sentence will be served consecutive to all other counts. On count 28, the grid block is 6A, and the prison sentence of 30 months will be served concurrently to all other counts. On count 29, the grid block is 6A, and the 30-month prison sentence will be served concurrently to all other counts. On count 30, the grid block is 6A, and the 30-month prison sentence will be served concurrently to all other counts. On count 31, the grid block is 6A, and the 30-month prison sentence will be served concurrently to all other counts. On count 33, theft in the first degree, the grid block is 2A. However, the sentence is pursuant to ORS 137.717, and pursuant to that statute, the sentence is 13 months of prison to be served partially consecutive. 9 months of it will be served consecutive to all other counts, and 4 months will be served concurrently to all other counts. And on that one, as well as the other prison sentences that I've just mentioned, will also include eligibility for all credits, including credit for time served and good time and work time credits. The credit for time served will be served nunc-pro-tunc, relating back to the original arrest for the probation matter pursuant to ORS 137.106 sub 4 sub A. There will be 1 year of post-prison supervision on this count, unlike the other counts, which carry 2 years of post-prison supervision. This crime is not a sex offense, unlike all of the other counts that I just went through. And on this one, I will also waive the financial obligations associated with the conviction. For that open case, and all of the counts I just went through, the aggregate sentence for just that case is 219 months of prison, followed by the 2 years of post-prison supervision on a majority of the counts, with credits as I've described earlier. I'll move to 20 CR 62443. That is one of the 2 probation violation matters that we are addressing this afternoon. And on count 1, also invasion of privacy in the first degree, I will revoke probation. The revocation is based on the new convictions on the 23 CR case. And I will impose, pursuant to the grid block on that count of 8A, 45 months of prison, which is the maximum on that grid block. I will include all credits, including credit for time served and good time and work time credits. The credit for time served will relate back to the arrest of the probation violation matter under ORS 137.1064A. I will deny eligibility for all programs, including alternative incarceration programs, and I will order that this sentence be served consecutively to the prison imposed on 23 CR 38838. There is also 15 months of post-prison supervision on this count. The term of post-prison supervision is reduced to 15 months to fit within the statutory maximum for this count. And I will waive the financial obligations associated with that revocation sentence. On the last probation violation matter, 19 CR 20957, count 4 harassment remains. I will revoke probation on that count, and I will impose 180 days of jail. Again, with all credits, I will deny eligibility for all programs, and I will order that that sentence be served concurrent to all other counts and cases, and I'll waive the financial obligations. The last count that remains on that case is count 8. Both of those counts are harassment. I will revoke probation, The basis for both revocations is the new convictions on 23 CR 38838. And I will impose 180 days of jail with eligibility for all credits, no eligibility for programs, and to be served concurrently to all other cases and counts with a waiver of all financial obligations on that count as well. The aggregate sentence pursuant to the agreement that the court intends to impose with each of those cases is the 264 months of prison, 22 years. And I believe that that addresses all of Mr. Walter's matters that are pending before the court. Mr. Samuels or Mr. Sarr, anything else for the record, and have I missed anything?
No, Your Honor, not from the state. Thank you.
Okay. Mr. Sarr.
Judge, count 10 is attempted invasion of personal privacy in the first degree, and that actually I don't believe it would be a sex offense, because the statute specifically says in 163701 that the court may designate invasion of personal privacy in the first degree as a sex offense. It does not speak to, it does not follow that the court is able to do that in ORS 163700, which is the second degree statute. I realize this is not that Mr. Walter was convicted of attempted in the first degree, not of the second degree variety of the statute, but I don't think, while the sex offender designation is accurate in the felony, I don't think it is in the misdemeanor.
And Your Honor, if I may, just 2 quick points on that. We have a stipulated agreement, and that's part of that agreement. Point 2 is 163A.005 little y. Any attempt to commit any of the crimes listed in A to X of this section can be a sex offense. And count 10 is an attempt, Your Honor.
Mr. Sarr, anything further?
No.
All right, the court's judgment will stand. Anything else for the record?
No, Your Honor. Thank you for your time.
All right, and before we go off the record, I just want to take the opportunity, probably my last opportunity, to thank again the victims for their statements. They are truly important for the reasons that I discussed earlier, and I also want to thank counsel on this case on both sides for their hard work, as well as the hard work of the probation department in this case, and the officers who investigated this case. We'll go off the record. Well, I think I wrote down this. Did I write down the wrong?
I swear that's what SAR says.
F 137-106 sub 4 sub A. You have what?
370 sub 4.
Maybe I need the correct statute again for the nunc-pro-tunc language.
137.370 sub 4.
Okay. Let's go back on the record for a moment.
Yeah, thank you so much.
All right. When the court included the relate back language on the credit for time served, I think I incorrectly stated ORS 137-106 sub 4 sub A, and that is actually supposed to be ORS 137.370, and then, I'm sorry, what are the subsections again?
4.
Subsection 4. All right, thank you. We can go back off the record. That was my fault.
No.
Is it okay if I just put these? Can I just hold on a minute? Okay.
Okay.
And then I have Caitlin's letter.
Is that right? And then, Mr. Samuels, did you want to talk to me about an unrelated?
If
Yeah,
you
absolutely. Do you want to just come around to the 14th floor lobby whenever you have a chance? Okay, I'll be there.
That's a thick stack.
Deputies, one moment.
Oh.
I need them to sign.
Yeah.
Thank you, deputies.
Do you want to go through? This is the sex offender. You want me to go through it? Yeah. So you want me to just have you sign it and I'll fill in the rest.
We have one more.
Oh.
I corrected that.
Okay. Hey, we got one more thing. This is just another copy of it where you picked, there was a couple of typos. It's the same.
264 and then.
Yeah.
Give me copies.
Mm-hmm. I'll send you.
Is that everything?
That is now everything.
Thank you.
All right.